Getting a call from United Airlines that a passenger needs to be removed from a plane has not established all of the elements of a lawful purpose. It's established a call. So what sort of training, and I apologize if I'm being too harsh here, maybe I'm being too harsh. Chat, please tell me if I'm being too harsh, but what sort of training does the officer need to tell him that this is not a situation that requires that level of violence? Good morning, everyone. I am Leonard French, your favorite copyright attorney, and I have a very interesting story today, a bit of a follow-up from a United Airlines case last year. You might remember that there was a gentleman who was yanked off of a flight after they told him that his seat was given to somebody else or something, and he didn't want to get off, and the police were called, and the police, was it Chicago area police, I think, the Chicago Department of Aviation? They were called and they came to his seat and asked him to get out, and then when he didn't get out, they pulled him out, and in the process, I think they hit his head and he was bleeding, and they settled with the United Airlines for some undisclosed amount of money, I believe. And it's all history. Well, it's not all history, as James Long was the police officer that hurt the man by pulling him out of his seat and hitting his head against the other seat's arm or whatever. And he is suing the City of Chicago, the Department of Aviation, and Ginger Evans individually. On or about January 2015, defendant hired plaintiff Long. Long's job title was interchangeably referred to as aviation officer, aviation security officer, aviation police. Long's shield badge identification outerwear identify him as police. As part of his training, he attended police academy. He completed Metropolitan Police Recruit Training Program, included mandatory firearms training. He studied at academy for 5 months. To complete his certification requirements, he had to pass the same written exams and final exams as Chicago Police Department officers, but with one exception. Despite the high probability that Plaintiff Long would have to arrest and detain individuals found violating or suspected of violating city, state, and federal laws, and also restraining individuals, he was not trained in the procedure of level of force continuum attached as Exhibit B. As commissioner of the CDA, Defendant Evans had the responsibility to ensure that the aviation security officers were being trained for a level of force continuum. I'm assuming that a level of force continuum is a spectrum of the rules of engagement for when you're allowed to use which force and under what circumstances an officer is allowed to escalate the force or the use of force to the next level. At the end of his training and after passing his exams, the Illinois Law Enforcement Training and Standard Board awarded Plaintiff Long a certificate for fulfilling all requirements that qualified him as a law enforcement officer. As part of his job duties, he had the authority to make, quote, arrests and detain individuals found violating or suspected of violating city, state, and federal laws, restraining individuals, etc. When defendant CDA hired Long on or about January 20th, 2018, it had a duty of care to Plaintiff Long to provide him with adequate training to perform the duties of his job. 2018? Is this a typo?
It has to be.
Seriously, someone help me out here, because this is after the thing happened. I'm assuming this is a typo. Defendant CDA and Plaintiff Long also covenanted to act in good faith and fair dealing with respect to each other as a matter of common law. Defendant CDA and Plaintiff Long further agreed as a matter of law that they would not do anything to injure the other in obtaining the fruits and benefits of Plaintiff Long's employment. In his position as an aviation police officer, Long was subject to the authority of Evans. Evans had the power and exercised influence in causing Long's termination, but for defendant Evans' negligence in training Plaintiff Long would not have lost his job. Despite acting as he was trained, Long was terminated on August 8th for the events that occurred on April 9th, 2017. The decision of the CDA to terminate Evans on August 8th caused Plaintiff Long mental anguish. Wait, what? I'm super confused. Is this another typo? You guys following this? If Long was terminated on August 8th and he's upset about Evans, why is he saying that Evans was terminated on August 8th? That has to be a typo, right? Defendant United overbooked flight 3411 on April 9th, 2017 and decided to force random passengers off the plane. The flight was headed to Kentucky. One of those passengers was Dr. David Dow. Dr. Dow refused to give up his seat. Defendant United called the aviation police to remove Dr. Dow from the plane. The first two responding officers talked to Dr. Dow and tried to persuade him to leave in a calm manner. That sounds normal. Dow responded by saying that I'm not leaving this flight that I paid money for. I don't care if I get arrested. Plaintiff Long was called off his lunch hour to assist the two aviation security officers. Dr. Dow continued to repeat that he was not going to get off the plane. United Airlines wanted Dr. Dow removed from the plane. Therefore, when their entreaties didn't work, Plaintiff Long, following his training, gently tried to remove Dr. Dow from his seat by putting a hand on his arm. Dow, however, started swinging his arms up and down with a closed fist. I don't remember that part. Plaintiff Long was able to pull Dow to the aisle, but Dow continued to fight and managed to free his arm from Plaintiff Long's arm, which resulted in Dow losing his balance and falling. Dow fell and hit his mouth on the armrest across from him, which caused an injury to his mouth. I don't remember all of this flailing from Dr. Dow. Dr. Dow's injuries were a direct result of his fighting with the aviation officers. I'm pretty sure there was video of this, but go look for yourself if you want to see. Plaintiff Long had assisted the subject by using minimal but necessary force to remove Dr. Dow from his seat. Defendant United knew or should have known that calling the aviation police on April 9th to remove a passenger who was refusing to leave their plane would require the use of physical force. Defendant United has admitted that it is responsible for the events of April 9th and that the aviation police officers involved were not at fault. Evan, isn't her name Evans? Evans stripped the aviation police department of its law enforcement credentials a few months after the incident by having one of the Chicago attorneys send a letter to the Illinois Board for Training Enforcement. I think that's the same Evans. I think this is another typo. This is major typo number 3. Like, this is not like the accidental misuse of, it's with an apostrophe or something. This is like parties' names are misspelled. I don't know. Maybe this is another person or something. I don't know where this Evan comes from, if it's not Evans. Beginning in or about April 10th, 2007, and culminating with Plaintiff Long's wrongful discharge, Defendant Evans, acting on her own behalf in the course of scope of her employment as Commissioner of Defendant CDA, but without any legitimate business purpose, conspired to have Plaintiff Long discharged from his position as Aviation Police Officer. Again, a minor typo there. From his position, Aviation Police Officer, intentionally or negligently causing the breaches and other harms alleged in this complaint. He was terminated on August 8th, yes we know. April 11th, Defendant Evans tweeted under the username Ginger S. Evans at Ginger S. Evans, a defamatory statement that the security officer who did this is not a law enforcement officer, knowing that this was a false statement and with the intent to cause severe emotional harm to Plaintiff Long. Also, on April 11th, Defendant Evans tweeted a defamatory statement that the actions of the airport security officers were completely inappropriate, with the intention of harming Plaintiff Long personally and also harming his reputation in the community and deterring third persons from associating with him. On April 14th, Evans tweeted that we do not arm security staff for good reasons, with the intention of harming Plaintiff Long's reputation, etc. Defendant Evans made similar oral statements to the press at official functions. Defendant Evans' oral and written statements were without a legitimate business purpose and with a high degree of awareness of their falsity and with the direct intention to harm Long. Further, Evans made these oral and written statements while keenly aware that it would cause Plaintiff Long emotional distress. These false statements imply that Long was not acting in his capacity as a police officer, that his actions were completely inappropriate, and that he was not armed for good reasons. Defendant Evans's acts, breaches, and other harms to Long further included, but are not limited to, publishing oral and written statements with a high degree of awareness of their falsity and obtaining deliberate and intentionally misleading omissions with the direct intention to harm Plaintiff Long. Defaming Long by implication, including but not limited to implying that Long sexually harassed and criminally stalked Defendant Evans. Defendant Evans made these oral and written statements without a legitimate business purpose and with a high degree of awareness that their falsity and with direct intention to harm Long. She published oral and written statements materially misrepresenting the nature of his job, breached the covenant to act in good faith and fair dealing, negligently failing to train Plaintiff Long, intentionally or negligently causing Plaintiff Long emotional harm. United failed to foresee consequences. As a proximate result, that's a legal cause issue for negligence. Plaintiff Long has suffered and continues to suffer loss in earrings?
It does say earrings. I didn't know that was a benefit of working for the CDA.
Hey guys. I'm so sorry. Mr. Long. Okay, I'm not going to insult Mr. Long's lawyer. They're doing a good enough job by themselves. Retirement benefits and other employee benefits as he would otherwise have received under his employment agreement, as well as emotional injuries. As a proximate result of defendant's acts, breaches, and other harms, he has suffered a loss in excess of $50,000. He's asking for punitive damages in excess of $50,000 and emotional distress, shame, humiliation, punitive damages in excess of $50,000. He's alleging negligent training, negligence on the part of United, intentional infliction of emotional distress against Evans and CDA, and negligent infliction of emotional distress against CDA and Evans. Breach of covenant of good faith and fair dealing as a matter of implied law, so we'll have to see what their argument is there. Defamation per sec or per quad. Tortious interference with prospective economic advantage, so they're saying that he's having trouble finding a future job, and intentional infliction of emotional harm against Evans individually. So that's interesting. How do you feel about that? I watched the video. The gentleman, Mr. Long, if he really was the gentleman who pulled Dr. Dow out of his seat, I don't know that I need any training to tell me that the way he did that was wrong. So that's just weird that he's alleging that he deserves money because he couldn't figure out how to treat a fellow human being like a human being. But at the same time, it was his job to do what he was told to do within reason. And so I guess, did he cross the line of reason? I don't know. If I was defending this thing, I would be saying that he knew, even without training, that you don't mishandle people like this in a crowded plane. Planes are sardine cans, man. And like, just think about this for a moment. The police have a policy of non-engagement on the road, for example, when a speeding car is speeding through their jurisdiction but otherwise not hurting anyone. If the speeding car won't pull over, many police departments won't take violent measures to try and pull the speeding car over. They'll take measures to try and get a description and a license plate number and all that, but they won't throw out the stop sticks, and they won't pit the car because someone could get hurt. And right now someone's just speeding and no one's getting hurt. It's crappy, and it's flying in the face of authority, and it's disrespectful and all that, but it's not hurting anyone yet. It could, but right now the police could do more damage by pulling over said speeding car forcefully, but with violence. So let's apply some of those principles here. Let's just think for a moment. Dr. Dow is in a seat. I think it was a window seat or middle seat. It was not an aisle seat, if I remember correctly. But even if it was, he's got to be pulled out of his seat in a crowded plane. What's the worst thing that's happening here? People are sitting on the tarmac. John Long, or whatever his name is, had to get off his lunch break. A few people might lose money because they didn't get home in time, or they missed their next flight or something. Okay, like, that's terrible, but no one is being physically, violently harmed. So what sort of training, and I apologize if I'm being too harsh here. Maybe I'm being too harsh. Chat, please tell me if I'm being too harsh, but what sort of training does the officer need to tell him that this is not a situation that requires that level of violence?
Leonard, I did find the use of force model for the Chicago Police Department, which the CDA is a department
Let's
of.
see it. So this is allegedly the Chicago use of force model. I'll take my face off so you can see it. And we'll zoom in. Too much. There we go. Maybe I can bring my face back. I can bring my face back now. Okay, this is the use of force model. Now this is from 2012. I don't know if it's been updated or something, but primary objective is to ensure control of the subject with reasonable force based on the totality of the circumstances. Whenever reasonable, members will exercise persuasion, advice, and warning prior to the use of force. But yeah, what does that mean? Oh, please, sir. Okay, now I can do it.
Well, they show you what it means. There's a diagram below.
Okay, when force is applied, a member will escalate or de-escalate to the amount of force which is reasonably necessary to overcome the subject's resistance and gain control. Okay. And let's see. They've got a chart here. Cooperative subject. Subject's cooperation without direction. Subject's cooperation only in response to direction. Nonverbal in response to verb. So movement to avoid physical control. Well, his was somewhere between passive and active resistance here. So what is he allowed to do? Hold, stun, spray. Wow. That is absolutely amazing that because he saw David Dow as an active resistor, that he went straight to this. What this skips over is only when you have lawful purposes. You have to know that you have a lawful purpose. Have you ever called the police for something petty? And the police come out and they're like, what are you doing? Like, we're not going to resolve your dispute with your buddy over who broke the skateboard. Like, that's not how police work. They at least shouldn't get involved, but, you know, most of the time will not get involved. So this document here points out something very important. They are only allowed to employ this use of force model for a lawful purpose. And getting a call from United Airlines that a passenger needs to be removed from a plane has not established all of the elements of a lawful purpose. It's established a call. You got a call from a citizen. I don't care if that citizen is the CEO of Microsoft, is the president, well, maybe the president of the United States does have some authority to do something more, but let's just say that it's a private citizen. You get a call from the CEO of United Airlines that says, we really need this passenger off the plane. I don't care what he says. If the CEO of United Airlines says, you know, the passenger's being unruly or whatever, when you get to the scene, you assess the scene yourself. What's going on? What is the situation? What's really happening here? You don't go straight to, okay, well, the CEO of United Airlines said remove the guy, so now I can start using my use of force diagram. It doesn't work that way. If he's employing the use of force diagram, it's because he has thought through that he has to affect a lawful purpose. And he was not ever affecting a lawful purpose. Mr. Dow had every right to be there. He had a boarding pass, he was seated, and he had not violated any of the rules of the charter that the airline's laws are basically that we had, the common carrier charter or whatever that we had reviewed. He had not violated any of that. So he was there lawfully, and there was no lawful purpose to employ the use of force model, in my humble professional opinion. So I don't think John Long has much of a case here. That said, it does seem like his police department threw him under the bus, and if they have not properly trained him, they should be accountable to that. I would really hate to see Mr. Long be rewarded for his misbehavior, at least what I perceive as his misbehavior. The proper way to handle the David Dow situation was to talk him through what was going on, to talk to the airline about what was really going on, to explain to the airline that he seemed to have a lawful purpose, and I cannot affect their removal of him without somebody explaining to me what lawful purpose we are affecting. So I don't understand how that officer could misunderstand the training he received, that he was only allowed to use the appropriate amount of force to be used to effect a lawful purpose. Just my humble opinion is that this police officer himself was overstepping the training he already had.
Well, isn't one of his arguments that he wasn't trained on the use of force model?
This is literally a 2-page document. I mean, it's literally this long, and he never received anything about this.
He said that he received all of the training except for the use of force, and therefore that's his charge for not being properly trained. But yet he also argues that he used the minimal amount of force necessary. So therefore, it seems like if he had been, he's almost arguing if he had been trained, that's the amount of force that he would have used.
Either way, I still don't see how you need training beyond, like, that's not the only document that would say that you're only allowed to put your hands on citizens when you have lawful purpose, when you have the authority, jurisdiction, and an actual crime or whatever. Like, for example, let's say the landlord at a big apartment complex calls the police and says, this guy hasn't paid his rent for a while, kick him out. What John Long says is, oh, well, the landlord called me and said so, so therefore I've got a lawful purpose. Totally skipping over, well, wait a second. Do I know what landlord-tenant law is? Is this a civil dispute or a criminal dispute? Is the non-payment of rent a civil dispute? Do I have a lawful purpose to throw somebody out of an apartment? And no, he would have received training, if he received a normal police academy training or whatever, that you can't just throw people out of apartments. So same thing with freaking planes. How could an aviation security officer not be familiar with the common carrier charter and rules and laws and all that says that you can't just throw people off of planes? I say that he had training and that he must have ignored it, but that's a little, I will totally admit that's a little bit of bias because I saw a video and I don't believe that David Dow was doing anything that warranted the level of physical violence that he received from Officer Long. Former Officer Long. So as much as Officer Long has suffered from his mistreatment of David Dow, and maybe there should be a jury finding on exactly how much former Officer Long deserves in compensation for not being trained, my personal attitude towards it is I don't think former Officer Long acted in accordance with just basic humanity without any training, but I'll defer to the court system and let them make their argument.
There is one more thing that I wanted to mention about this document. It's really interesting that it says if the subject is cooperative without direction or variable distance, then it may be excessive for the police to even be there. So what it's saying is this is not a situation where the police should even be called, right? And if the police are there, it's like you shouldn't even be there. Like the subject is clearly not even close to breaking the law, because that's what the circle with the line through it and the red and blue, it means it may be excessive to do this, you know?
And so those two squares that we're looking at here, this one and this one, are what you're talking about.
Yeah. That was what you mentioned
where
earlier.
the line goes through, and it's a gray situation. In this case, it's more like a blue and red, so a purple situation.
Yeah.
But you're on the line, and honestly, what do we tell you about being on the line? Better safe than sorry is a pretty safe one to go with. Where do you want to be on this line? The safe side is letting David Dow go. Like, the safe side is letting him de-escalate back to cooperation. guess what? The officer can obtain cooperation by the officer not doing the unlawful act of trying to remove a boarded passenger from a plane, who is now simply scared. I mean, you get this? Like, the officer wants to make money off of himself being scared of the reaction and being fired and all that from this. What do you think David Dow felt? Like, I get it. David Dow got compensation. We don't even know how much, but I'm guessing a fairly decent amount of compensation. So I'm not trying to get, everybody all pitying David Dow again, but shouldn't have happened in the first place is what I'm trying to say. Any of us shouldn't have to fear this happening to us just because we got on a plane. Thank you very much to our sponsors. Right now we have a $500 video sponsor, Kareem Harper, who is sponsoring a video about the Cambridge Analytica Facebook data privacy situation. We're working on a script for that. Give us about 2 more weeks on that and we'll be good. Our $50 plus supporters for April are DJ Gilcrease, John Steele, Gavin Barnard, The Godslain, Evie, Andy, Kyle Mudrock, John H. Anderson, Veramintane, Sean McNamara, William Gonzalez, Michael Pierce, and LVE. Thank you all very much for your support. And thank you to the 210 $5 plus supporters that are supporting. I'll have you scrolling on the screen when we do the video, as well as you're on the LED panel behind me, which I tried to be out of the way a little bit more this time, so hopefully that worked out for you. Thank you all the supporters, including the ones that are not listed. Your support is invaluable. It keeps this channel going. The YouTube money at this point is way less than it used to be, and it's all working out to be about the amount of money we need to keep this channel going. Have a great week. I'll see you in the videos as they drop. I'll see you from Washington, D.C. later this week, and then we'll see you next Sunday for the next Sunday show. And who knows what happens after that. The world's a big place and there's a lot to do. So it's interesting. Love you all. See you later. But Defendant Evans's, I will get this. Defendant Evans's acts, Plaintiff Long was called off his lunch hour to arrest the 2 aviation security officers. To assist. Let's redo that one.